Hello and welcome to another episode of Insurance in Canada. I'm your host, Rick Beneva. Thank you so much for joining me. On today's episode, we are looking at claims scenarios, recent court cases, tribunal cases involving certain claims from certain insurance companies, because no matter how much you study insurance, no matter how much you study policy boardings, in the end, it is going to be up to the courts to make the interpretation of how a coverage or exclusion is supposed to be applied. So we're going to take a look at four stories involving four claim scenarios. So without further ado, here is Insurance in the News. So our first story looks at a case involving the use of a vehicle, how it was reported to the insurance company, as opposed to how it was actually being used and the ramifications for coverage. So whenever you insure a vehicle with an insurance company, you are required to disclose how the vehicle is going to be used, and the vehicle is going to be rated as such. If you're misinterpreting how the vehicle is going to be used, it could have implications if you were to try and make a claim later on, which is what this particular case indicates. So let's take a look at this. This is from Ontario. Ontario court rules pleasure vehicle was a company car all along. Commercial plates, hay hauling, and business expense claims. When does a pleasure vehicle become a company car? An Ontario court ruled a truck insured for pleasure was actually a commercial vehicle with real consequences for insurer priority. The decision, released on April 29, 2026, arose from a head-on collision on October 11th, 2020. So this has been going on to the courts for quite a number of years. That left John Krolzik seriously injured. Krolzik was driving a 2004 Chevy Silverado owned by his elderly mother, Sophia Krolzik, and insured by Gore Mutual Insurance Company as a pleasure or commute vehicle. The broker had been told the truck was used for pleasure or commute not more than 5 kilometers. So pleasure use, you're not using it to commute to work or to school, even part way. So if you're using your vehicle not to drive to work, but say drive to the train station or drive to a transit station, that is still using your vehicle for commuting purposes and should be informed to your broker or agent or insurance company that you are using the vehicle for those purposes. The reality was quite different. Krolzik was the director, vice president, and general manager of Corral Farms, Inc., a family farming corporation. He used the Silverado daily to travel between two farms roughly 15 to 20 kilometers apart, a crops farm in Baltimore and a cattle farm in Cobourg, Baltimore, Ontario, not Baltimore, Maryland. The truck regularly hauled bales of hay between the two properties and it was used to pick up parts and supplies. It carried commercial plates since 2017, and all fuel maintenance and repair expenses were claimed as business costs by Corral Farms, Inc. I should point out the commercial plating. In Ontario, commercial plates are assigned to vehicles based on the vehicle type, not what the vehicle is going to be used for. So all pickup trucks in Ontario would carry commercial plates unless it's being declared to the Ministry of Transportation of Ontario that the vehicle is being a particular vehicle is being used for pleasure use only. So it does affect the annual fee that you pay for the vehicle registration, which in Ontario, private passenger, pleasure use vehicles, private passenger vehicles aren't charged anymore for vehicle registration like they used to, but commercial vehicles are. So that's why somebody would want to declare their pickup truck as pleasure use only. But definitely when it comes to the plating doesn't necessarily indicate to an insurance company that your vehicle is being used for commercial purposes, but there's other ways insurance companies can detect that. And obviously the company that the insured was a director of, claiming the cost of the use of the vehicle as a business expense, that's definitely going to indicate what the vehicle is actually being used for. Let's get back to the article. After the accident, Krolzik applied for statutory accident benefits through Hamilton Township Mutual Insurance Company, which insured other vehicles tied to him and his wife, as well as a Ford F-250 owned by Corral Farms. HTM pushed back, launching an arbitration to determine which insurer held priority. The dispute turned on Section 3 Paragraph 7, subparagraph F, subparagraph 1 of Ontario Statute and Acts and Benefits Schedule, which deems a person the named insured under a vehicle's policy if that vehicle is being made available for the individual's regular use by a corporation, unincorporated association, partnership, sole proprietorship, or other entity. If that threshold was met, Gore Mutual, as the Silverado's insurer, would carry priority. Arbitrator Kenneth Białkowski found that it was. The truck's annual mileage confirmed by VIN history was in stark contrast to its declared pleasure use. He found that Zofia Krolczyk, 88 or 89 years old at the time, no longer licensed to drive, and later in a nursing home, had not made the truck available in a personal capacity. She had done so as a shareholder and director of Corral Farms. Krolczyk, the arbitrator noted, had full control over who would use the Silverado and how the vehicle would be used. The arbitrator also found the Krolczyk family operated as a family unit or joint venture and other entity under the regulation, collectively running both farms after the death of Krolczyk's father. The judge dismissed the appeal, finding no error in the arbitrator's reasoning and citing Kingsway General Insurance versus Gore Mutual. Gore Mutual was ordered to pay $6,500 costs. The message for insurers is clear. How a vehicle is classified on a policy is not the final word in a priority dispute where actual use, mileage, records, tax filings, and the structure of family business all point the same way. That is where the evidence leads, regardless of what was reported to the broker. So in this particular case, it wasn't necessarily a issue of coverage, but which insurance company would be paying the benefits based on the use of the vehicle. However, still, you don't want to mess around with your coverage to try and save some money on your auto insurance by declaring the use of a vehicle to be something that it's not. It's not worth the risk. And like I said, insurance companies, have been around for a very long time and know the tricks to trying to figure out exactly how a vehicle is actually being utilized. So not worth the risk. Our next article, a homeowner's dog bites the dog walker, a liability riddle, who owns the dog. So this is a property liability claim. An interesting one. I don't think I've ever seen this kind of scenario ever pondered before, so it'll be interesting to see how this worked out. A dog walker bit by a dog in her care was the owner of that dog at the time of the attack under the Dog Owners Liability Act, and therefore can't claim $1 million in liability against the dog's true owners, the Ontario Court of Appeal has found. So the Dog Owners Liability Act is a Ontario statute. So most other provinces and territories in Canada have a similar type of piece of legislation, but what we're talking about here does apply to Ontario. So what the court ruling found may or may not apply in the province or territory where you live. The case highlights nuances in how insurance covers liability associated with dog walking. Michael and Amanda Luciano hired a dog walking company to look after their dogs, a large male boxer named Forrest Gump and Benny. Amanda Nigro, who worked part-time at the dog walking company, began walking Forrest in November 2021. She looked after the dogs at the Luciano's house about 3 times a week and had a key to their house. Forrest developed an infection in his foot. In February 2022, the vet advised the Lucianos that Forrest was not to come into contact with mud or anything that could cause infection. It was recommended that Forrest wear rubber booties when walking in wet areas. Nigro attended the Luciano's residence after looking after the dogs. On March 24th, 2022, alone in the home, she let the second dog, Benny, outside to use the washroom, and Forrest refused to go. A bit later that morning, Nigro wanted to let Forrest out in the backyard. Since when the snow covered the backyard, she decided to put booties on Forrest before letting him out. It was the first time she tried to put booties on Forrest. As she approached Forrest with the booties in one hand, As she approached Forrest with the booties in one hand, the dog lunged at her, bit into her left arm, and started shaking. After she got her arm loose, Forrest continued to attack her, biting various parts of her body. Nigro suffered injuries to her abdomen, left upper thigh, and both arms. There was no history of aggression behavior by Forrest in Nigro's presence or otherwise. Nigro sued Luciano's for general damages of $350,000, special damages of $650,000 for a total of $1 million. The Ontario Superior Court dismissed her claim, finding that Nigro possessed or harbored the dog at the time of the attack. The DOLA, Dog Owners Liability Act, defines owner of the act as follows. Owner, when used in relation to a dog, includes a person who possesses or harbors the dog, and where the owner is a minor, the person responsible for the custody of the minor. Nigro appealed to the Ontario Court of Appeal, which upheld the finding in the lower court. So, let's see, is there anything else of interest? Would the dog owner's injuries be covered under the insurance for the incident? It depends. Commercial underwriter research on broker websites shows that most Canadian home insurance policies include personal liability coverage, which can apply if the homeowner's dog issues someone, which is true. Any homeowner's policy, condo unit owner's policy, tenant's policy would have personal liability, legal liability coverage, and that sort of coverage does include liability for damages caused by your pet. Keep in mind, some insurance companies do have a breed list, an excluded breed list. Not every insurance company has this, but some do. So if you own a pet of that particular breed on the exclusion list, then you may not have coverage if your pet who's on that list injures somebody. So it's a good idea to contact your broker or agent to confirm with them if your policy has such an exclusion and which breeds are actually on that exclusion list. However, home insurance policies for animals may apply, including for breed restriction, a known aggressive history of a pet, a business arrangement, or liability related to animals. If a dog walker owns a commercial general liability policy, that might cover a dog walker if someone else was bitten while the dog was in his or her care, which is very true. I know there's a lot of dog walkers who are self-employed and have not considered a commercial general liability policy, but it's rather critical you do consider this type of coverage, at least the liability portion, just because you might have worked with dogs for a particular dog for a long time, but you never know what could happen, and you lose control of the animal that you're walking and they injure somebody. Well, you're as responsible as the dog owner is going to be for the injuries that a third party suffers. So if you do know somebody who's a dog walker and they haven't purchased this type of insurance and they are self-employed, yeah, this is definitely something they want to consider. Typically a CGL would not cover dog walkers if dogs attack them while in their possession, which is true. Commercial general liability is to cover third parties. It does not cover the dog walker themselves. And as the article goes on to mention, coverage for medical expenses in that case may fall under workers' compensation, WSIB in Ontario, personal accident or injury insurance, or health insurance. So you definitely need a first-party insurance coverage to cover injuries that the dog walker themselves suffer because of a dog bite for the dogs that they are looking after. But commercial general liability is there to cover the liability for the business actions of the dog walker and for the dogs that they have in their care. So an interesting case because this is not a simple case of negligence. You do have legislation, certain pieces of legislation that overrule the common rules of negligence, and the Dog Owners Liability Act is one of those pieces of legislation. So it's interesting to see how this particular case turned out. Next up, a situation from Quebec. I know our previous cases were from Ontario. I've been trying to find cases from outside of Ontario. It just seems to be Ontario cases seem to be popping up a lot these days, but I did find one from Quebec. Another interesting case, Quebec court shuts down bid to force Beneva to defend policyholders. Beneva is an insurance company. The policyholders' own concession at the appeal hearing sealed their fate. A $30,000 damage claim was not enough to compel Beneva Insurance to defend its policyholders, Quebec Court of Appeal has ruled. In a decision handed down on April 30th, 2026, Justice Eric Hardy dismissed an application for leave to appeal a lower court ruling that had rejected a so-called Wellington-type application the legal tool available in Quebec that allows policyholders to force their insurer to pick up the cost of their defense in a lawsuit. And keep in mind, the Wellington type application they are talking about applies in Quebec. Your particular province or territory may have a similar type of rule or system, but what we're talking about is here in Quebec. So on your any sort of liability coverage, whether it's commercial general liability, personal liability on a personal property type policy or an automobile liability, the duty to defend is always greater than the duty to cover. So even if there's the slightest chance that coverage might be afforded by the liability section of a policy, the courts will force an insurance company to spend the money to defend their insured, because normally the insurance company is required by the terms of the contract, the policy itself, to pay for a defense against claims that would be covered under the policy. If a claim is not going to be covered under the policy, then no, there's no defense. The insurance company is not required to pay for a defense. But sometimes you get this gray areas where it might be possible. There might be like a 1% chance that somehow there is coverage for the claim that's being presented to the insurance company. So even if there's that minimal chance, at the very least, the insurance company has to pay to defend, not necessary to actually cover the damages themselves. The damages that the court rules may still fall under an exclusion, but like I said, the defense costs will be paid, and the insurance company wouldn't be able to force their insurer to reimburse them for the cost to defend. The dispute began with a residential property sale. Roxanne Joubert Usanio and Matthew Cryans Kerouac bought a home from Simon Lamontagne and John Sebastian Bergeron. The buyers later filed a latent defects action against the sellers, seeking an annulment of the sale, the return of the purchase price, and $30,000 in damages for inconvenience, trouble, and disruption subject to adjustment. The buyers alleged that they had been victims of fraudulent representation. Facing that lawsuit, Lamontagne and Bergeron turned to their insurer, Beneva Insurance Company, for a defense. When Beneva declined, the sellers filed a Wellington-type application to compel a defense on February 12, 2026. Superior Court Justice Suzanne Oulet dismissed that application, her finding the $30,000 damages claim was mere ancillary to a claim that was not a claim for damages. So the personal liability coverage under a personal property policy, commercial general liability coverage, the liability under your automobile liability under the automobile policy covers bodily injury and property damage. So in this particular case, the plaintiffs were not claiming any sort of bodily injury that they suffered or any sort of property damage that they suffered. They're claiming fraud on the part of the insureds. So fraud would not be something that's going to be covered unless there's some sort of corresponding property damage or bodily injury. So this is why the insurance company would have denied the claim and denied the defense, because the type of damages being claimed by the plaintiff wouldn't have been covered under the policy. Therefore, there shouldn't be any sort of defense, even especially seeking the annulment, return of purchase, $30,000 in damages for inconvenience. Once again, we're not tying it to any sort of bodily injury or property damage. So this is where once again the basis for denying the claim, because even those damages, it's not claiming, they're not making any sort of statement in their statement of claim, the plaintiffs, that this is from any sort of bodily injury or property damage, therefore not triggering any coverage under the policy. The sellers then sought to leave to appeal on April 28, 2026 hearing before Justice Hardy. They conceded a point that claims for annulment of the sale and restitution of the purchase price were not covered by their insurance policy. The entire Wellington-type claim, they admitted, rested strictly on the $30,000 damages claims for inconvenience, trouble, and disruption, a claim that was attached to the principal action for annulment. Justice Hardy acknowledged that the procedural threshold for a leave was met. A ruling that rejects a Wellington-type application is the kind of decision likely to cause the insured harm that a final judgment cannot remedy, but that alone was not enough. He found the proposed appeal had no reasonable chance of success and that the lower court's conclusion presented no apparent weakness. The application for leave to appeal was dismissed with court costs. For insurers and claims teams across Canada, the decision sent a clear signal. When the principal claims in a lawsuit falls squarely outside policy coverage, a modest damage claim tacked onto that action may not on its own be enough to trigger the duty to defend. Quebec courts have shown they are willing to look past the label on a claim and examine whether the real dispute is one the policy actually covers. If it is not, an ancillary claim riding alongside will not change the outcome. So, lesson learned for everybody in the insurance industry, but how to really look at liability claims, not just look at what the plaintiffs are claiming in their statement of claim on the surface, but to really dig into what the actual circumstances of the claim and what the actual circumstances of the damages are to see if that really is the damages being the source of the damages being bodily injury or property damage, or whether it's something that's not covered inside the policy itself. So interesting court case there. So our last one for today. An interesting situation. A man jumps out of the way of a truck, which then kills his fiancée. Is he involved in an accident? So this is dealing with automobile accident benefits. And this one is from Ontario. Sorry, like I said, most of these cases I can find lately seem to be coming out of Ontario. But this is an interesting case. So, a man who instinctively jumped out of the way of a U-Haul truck and saw his fiancée, who was walking beside him, get struck and killed by the vehicle, was involved in the accident and thus entitled to accident benefits for psychological injuries. The tribunal has ruled the man's auto insurer, Coachman Insurance Company, denied his claim on the basis that the truck had not touched him and that the psychological injuries he suffered were based on seeing his fiancée get killed. That made him simply a witness to the scene, the insurer argues, so he wasn't really involved in the motor vehicle accident. That's true, but if you look at the definition of an insured under the accident benefits section of the Ontario Automobile Policy number 1, the owner's policy, psychological and mental injuries suffered by an insured because of injuries suffered to a close family member, the insured is able to claim accident benefits for those psychological or mental functions. So normally it's the family members we're talking about, like one generation away, so parents, children, brothers, sisters. When you start getting into like second cousins and stuff like that, that's not your chances of being successful trying to claim accident benefits for mental or psychological injuries because your second cousin was involved in an automobile accident. Yeah, you're going to be very unlikely to be successful in that. But it'd be interesting because this is the insured's fiance, not spouse. So the question becomes, does the person qualify as the under Ontario law as a common law spouse? So let's take a look at the rest of the story. Coachman submits that the dominant feature of the claimant's in my view, the dominant feature is the U-Haul truck that caused the claimant to take evasive action to avoid injury. I also find it was reasonable for the claimant to believe his life was in danger by the approaching vehicle, which only seconds later collided with and killed his fiancée who was beside him. Jaspreet Dhaliwal and his fiancée were walking together on the sidewalk on March 8, 2025 when the U-Haul truck suddenly drove up onto the curb towards the couple. Dhaliwal jumped out of the way, but the truck hit his fiancée, who was pushed into a storefront window and killed on impact. That's horrifying. Emergency personnel attended the scene and an ambulance transported Dhaliwal to the hospital. The couple had been in a committed relationship for 3 years prior to the accident. They were engaged to be married in July 2024, moved in together in September 2024, and were to be married in July 2025. So a lot of this seems to indicate that they would meet the definition of common law spouses. So those mental injuries, those psychological injuries suffered by the claimant, in my opinions, would seem to be covered under the accident benefits section. But let's take a look at what the rest of the case states. At an examination under oath 2 months after the incident, Dhaliwal testified the truck missed hitting him by approximately 1 meter. The vehicle did not hit him. He did not fall to the ground and was not physically injured. His accident benefits claims were for acute psychological and emotional fragility. The LAT, or Licensing Appeals Tribunal, decision states, which he submits he continues to manifest since the accident. In denying benefits, Coachman relied on several LAT decisions that found claimants who witnessed an accident are not involved in the accident, even if there is a fatality. In these decisions, the tribunal found the claimant has to be physically injured to be involved in the accident. LAT rejected this argument because the psychological pain was caused by his fear for his own life, and not simply the trauma of witnessing what happened to his fiancée, which is interesting because they went in a very different direction than I thought they would in trying to justify qualifying the claimant for the accident benefits. I thought they would stick with the extension of the definition of accident benefits to people who suffer those mental psychological injuries, to people whose close family member suffers an injury in an automobile accident, but they're trying to focus on the insured themselves, the claimant's injuries, as being tied to the accident as opposed to what happened to the fiance. I agree with Dhaliwal that he was not a simple witness to the accident, nor did his involvement arise from simply witnessing the aftermath of the accident. Morissette wrote, "He was in mere feet of the approaching U-Haul truck and had to physically jump out of the vehicle's path to avoid possibly being struck. In my view, but for the approaching vehicle, the situation would not have required Dhaliwal to take immediate action to evade the approaching vehicle. Had he not jumped out of the way, he could have sustained physical injuries or worse. In my view, Dhaliwal was engaged as a participant, hence he was involved in the accident." So, an interesting rationale. I wonder if this, I know when it comes to decisions presented by the Licensing Appeal Tribunal, they don't set precedents like a court case does. So future cases brought before the LAT that are similar to this particular situation do not have to abide by this particular decision. It can be used to support a future plaintiff's position when it comes to qualifying for accident benefits. But it's interesting in this particular scenario whether that's going to open the door to other situations involving people who were near misses, were not actually struck by anything or anyone, but still are claiming some sort of mental or psychological injury, whether that will still be used to, this particular case be used to support their claim as well, and whether we might possibly see future claims being paid out that were never intended to be paid out, and how that can affect the automobile insurance in Ontario. And that is it for me for today. Thank you so much for joining me. If you like what I do here, please like and subscribe for more. Please share this video with others who you think might be interested in the information presented today. Make sure to follow Insurance in Canada on Twitter/X. And until next time, bye-bye.